Okay, you have Rule 445, Case Management Statement and Conference. No later than 15 days prior to the Case Management Conference, each party must file a Case Management Statement as detailed in California Rules of Court. Okay, here's the form for that, and you get that at the courthouse, and it'll print it out at a printer with all the forms at the courthouse, and you have to figure out how to navigate the computer. Someone won on case law and force the courts to at least provide forms. This is form CM 110. But also at the clerk's office, you can get the rules of court, and then just make sure that you get this and the summons and complaint forms, and make sure you have someone else serve the summons and complaint to the right individual agents of service or whoever's supposed to be served, because you can't do it. You can never send a proof of service. You have to have a friend do it. But the summons and complaint, I highly recommend you hire like a Signal Hill attorney service, or there's a lot of these businesses out there that do serve. All the attorneys go to them. So ask somebody at the courthouse where they're located and you'll find one. Anyway, so I think coming out of the box here, this is a little challenging for me. But really what you do is you have this form here, the case management statement, and you got to mark the box. Is it over 25,000 unlimited? And you go to that window, and then you have to do this 15 days prior to your case management, and otherwise they sanction you if you don't fill out this form. And then the sanctions, like I had talked about, they sanction you $1,000, $1,500, because the defense simply says, I never got a case management form, and you have to serve this with a proof of service. And this particular proof of service says don't serve this as a summons and complaint. And some of these proof of services have different numbers on for different particular court cases. So you have to try to figure out what that is. But they're easy to fill out, this particular one. Once you you just do it. The proof of service is fairly easy, and these forms. You want to get one of these blank pieces of papers, because you're going to stick this in with the numbers here for all your pleading work. And you don't necessarily have to have this line on this side, but you're going to stick this in your printer, make a bunch of copies, 100 copies, and stick it in backwards, so that when your print comes out, it comes out with your brief and all this to the judge. And I put up some examples on that. So then you would have to meet and confer. There's another form, and it's another rule they have, and you have to basically the top is always usually the same, and then you have to serve it with the proof of service. Then you have these other forms. You'll do your pleadings. The most important part is your case law, your memorandum and points and authorities. After you do your pleading, you can also put them in your pleadings here. But make sure, this is where they kick you out of court and sanction you for not having appropriate case law to your circumstances. And this particular case law was good for this case that I was on, but others I was really struggling with. And you have to have exhibits, just fairly easy, and then number them. The more organized you look, they'll give you the time of day in pro per. Remember, judges hate attorneys, attorneys hate pro per litigants, and judges hate pro per litigants. And no one wants to be in pro per, but unfortunately lawyers are too busy and don't want to have to deal with complex cases and stuff. So there's all sorts of reasons, or if you don't have money. I did go on the internet, found some awesome case law, and then one particular judge, he didn't like the fact I went on the internet, but the other case law I found was awesome, especially on Constitution, on the Supreme Court Constitution, State Court, and then the Supreme Court Federal when you go online, that particular case law is pretty good. Otherwise, when you're just in front of the judges, try the law books. They're really into you having to do research and going to the law library or borrowing books. And there's a law dictionary called the Black Law Book that is just like a dictionary and explains legal terms. So then, of course, you want to reach to default or some type of a judgment. I did default one attorney. He had no legal malpractice. So don't hire any of these attorneys that are unemployed, because they're not going to have any legal malpractice insurance. And even though mine had his own law firm, he just basically quit and took off, and my $17 million judgment, because he didn't show up to court, immediately defaulted him. It doesn't count. I mean, I can't collect from him. You could try to garnish his wages and all that, but I didn't do it. And I had so many problems with different attorneys that I felt I would go after the first one I hired for this craziness in the courts. So basically, you're trying to get this last form, Judgment 1. You're trying to win, and whatever the judge decides, then you have to fill out all of this. And basically, my accountant was really smart. And if you have an accountant, he went ahead and put lost wages for me and tallied it all up and showed how, you know, what taxes are paid and all that. And he gives a great description on health insurance damages and lost pension. And this is really crucial, because this starts to add up for a lot of money. And $7,840,000 was my total amount that I was out of, and I wouldn't have figured that. And that's not even emotional distress, your injuries, pain and suffering, your substantial injuries, and you can negotiate all your medical bills down, so kind of remember that. But anyways, I probably won't. Have a good attorney that, especially if you have a pension and a health care and you've lost all that, that can figure out how to read the your pension booklet. And usually maybe the attorneys are up to date on these laws. My particular attorney or accountant was, and my attorney, so that helps, because when you have to file these judgments, you want them to know. It'll be easier for you to fill out the form and all. And remember, a good thing to know is there's it's Acrobat Professional, like a service that you can pay $450, and it puts everything into a file. And that's good to know if you're a union steward or something, and you need to put everybody's PDF file and you can track things and help them out and fill out forms and grievances a lot faster. Same with your court ordeal or anything. It costs $450 for the program though, and then having a good scanner and fax is good, because then you can scan everything in, and then if you want to borrow money from the lawsuit funding companies, you just scan it, send them an email and a PDF file and an attachment, and then you don't have to send all these documents and waste your time with mail cost and making copies at Kinko's. And Kinko's also will do the PDF files for you. You just tell them, can you scan this in if you don't have a scanner? And they'll put it in a PDF file, but the problem is they can only mail you so much in a PDF file. It can only be like 10, I forget what the count is, but like maybe 25 pages. I did put all of mine on DVDs and CDs, which you can do, and then you can purchase audio from your court hearings, which is another $40. But for the smaller cases, obviously you don't have to worry about that. But I did learn a little bit about a PDF Professional Acrobat 8 that will help you get organized. Otherwise you're going to be buying boxes like I had to do, and trying to keep track of all this, and by then you're ending up being a law firm, which you shouldn't have to.